Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. You have all seen in the press as well as the media about the developments or Maha twist in Maharashtra. Ultimately, yesterday, the rebel leader Eknath Shinde, he was sworn in as the Chief Minister of Maharashtra state. In this connection, the Honorable Supreme Court of India on day before yesterday night, it has declined to interfere with the floor test ordered by the Governor Honorable Koshyari, Balwant Singh Koshyari. Now, many of the students, they are interested to know what is floor test and who can order the floor test. Can the court supervise the floor test? If any MLA is absent, can anybody take action if he is absent in the floor test? All these questions are actually literally running in the minds of the students. They want to know the answers. Therefore, I am making this video. Actually, it's a political issue. The issue, you all know that the rebels under the leadership of Eknath Shinde, they revolted against the present Chief Minister Uddhav Thackeray. So ultimately, he was ousted and Eknath Shinde was elected. In the meantime, so these people have camped in Guwahati. So many things have taken place. So Uddhav Thackeray, through the Deputy Speaker, he wanted to disqualify them under anti-defection law, but it was stayed by the Honorable Supreme Court of India up to July 12th. In the meantime, Governor ordered for the floor test and Supreme Court declined to interfere with the floor test. This is the background story. Now, what is floor test? That is important. So, floor test is a test intended to test the majority of the MLAs. Suppose if there is a competition, if there is a rift, if there is a fight between two competitors, two rebel CM candidates, that so and so has got majority, then it is for them to prove their majority. Somebody will be called and he will be asked to prove his majority. This is what is envisaged under Article 175 Clause 3 of the Constitution of India. You all know, normally Article 174 says the governor can summon, the governor can dissolve, or the governor can prorogue, sine die, you might have heard that name, the assembly, right? So according to Article 175, he can ask for the floor test. Suppose if the assembly is in sessions, definitely the speaker has to conduct the floor test. If the assembly is not in sessions, these situations normally the assembly will not be in session. At the time, the governor has to appoint the senior MLA as a pro tem speaker and he has to conduct the proceedings regarding floor test. Right? So this is the constitutional point involved in the floor test. So the day before yesterday, Governor Koshyari of Maharashtra directed the Maha Vikas Aghadi, that is combination of parties, or Uddhav Thackeray, to take a floor test to show that it enjoys the confidence of the legislature, and the test is posted to yesterday, that is 30/6/2022. Right? Why? The floor test upholds the collective or collected accountability of the elected government to the legislature. In this connection, please remember 4 or 5 important cases. The most important is SR Bommai versus SINH of India 1994, where the governor, the then governor, late Shri Pendekar Venkateswara, so seeing the persons who were present before him in his Raj Bhavan, then he said that he dissolved the government. It is not correct. Then Supreme Court said that floor test is the competent action. It is the correct procedure to check up whether the majority is there or not. Otherwise, those MLAs at the time, the MLA stated that their signatures were forged and some duped persons were put present. Same thing happened in 1982 or so, 1985 if I am correct. So when Ramlal was the governor of Andhra Pradesh, Nadandla Bhaskara Garu became the CM. Like this only. But anyway, in 1994, SR Bommai, it is a landmark judgment which says that the floor test is the correct method to assess the majority. Second case, actually in the article floor test, actually this thing in, please remember, as regards Article 356, Dr. B.R. Ambedkar said it should be a dead letter, but nowadays it is being commonly used or misused, you know. Second case is CHAUHAN versus Union of India. This is in, Shivraj Singh Chauhan versus Speaker, Madhya Pradesh Assembly. So this is actually, in this case, the important point, the purpose of the conduct of the floor test is to avoid the possibility of the horse trading. So definitely 50 crores, 60 crores amounts will be offered to these people. So all these things, once again, we are going to touch the politics, we are not. So please remember, government or the governor is empowered to hold the floor test through speaker. If the speaker is not there, yes, as I told you, the senior member will be allotted, will be empowered or to conduct. He will be called as the pro tem speaker. For this, please remember the judgment. G. Parameshwara versus Union of India 2018. This is happening in Karnataka. And another case, if two or more persons claim the majority, Jagadbika Paul versus Union of India, it is also a very important case. So there in Uttar Pradesh, 2 or 3 persons, they claim the majority. So all of them, so please conduct a floor test. So floor test is that much important. But in the beginning I told you, the court is barred from conducting or from monitoring the proceedings of the House. No, you cannot assume the powers. You may be knowing regarding Article 50 of the Constitution, doctrine of separation of powers. Everybody has got to do his own job. So it is for the speaker or it is for the pro tem speaker to conduct the floor test. So as per Article 212 of the Constitution, it bars the court from monitoring the proceedings of the House. And second point, in this Chauhan case, court cannot compel any member to be present for the floor test. They can skip also. I will tell you another case law regarding the skipping. So court cannot compel any member to attend the court. This is also stated in the Chauhan case. However, you know, the political parties, they can give a whip. If any person defies the whip or if any person does not comply with the whip, definitely it will lead to his disqualification. You know this is a political aspect. Then please remember, if the CM fails to go for the or to comply with the floor test, then it can be construed as a lack of majority, as stated in the case of SR Bommai. It is already clear. So please remember, no doubt, sometimes governor's satisfaction is important. Satisfaction is the most important one. So it is not immune from the judicial review, as stated in the SH Chauhan case. Of course, they will not interfere with the order. They will interfere with the mode in which it was made or the conditions it was made, in which it was made. So that is the review. Review power, simply know that review power is there. Then in the last occasion, an important point has come, legal point. The Supreme Court has deferred the Deputy Speaker not to conduct the, not to disqualify these people up to July 12th. In the meantime, the governor has called for the floor test. Then it was argued in the Supreme Court, but that pending the judicial order, pending the Supreme Court orders, the floor test cannot be conducted. In this connection, reply is there from SH Chauhan case itself. Floor test need not be deferred. The floor test need not be deferred due to pending disqualification proceedings. So both of them are separate. That is with the speaker or judicial action. This is with governor, administrative action, procedural action. So please remember. In the case of Pratap Govinda Patel, Pratap Gowda Patil appeal and others versus State of Karnataka 2019, the court allowed rebel MLAs to skip from the test from Karnataka Assembly. That's why in SH CHAUHAN case, I told you that the court cannot compel members to be present. Here they can skip also. Nobody can do anything because it is only directory. It is not mandatory provision. So these are all the particular case laws relating to the floor test. I think by now you have understood and have covered almost all the points basing on the SR Bommai, Shivraj Singh Chauhan, G. Parameshwara versus SINH of India, then Jagadbika Paul UP case, and also last case is Shivasena versus SINH of India. So Pratap Gowda Patil versus State of Karnataka. So please note down these cases. If you find time, read them, at least read the summary and substance. Definitely you will know many things about how to conduct the floor test and what are the legal points in this floor test. So already 10 minutes time is over. I will say bye. Thank you very much.